the failure to report a federal felony is not a crime. The defendant has to have some kind of act designed to conceal the fact that a federal felony has been committed, and recognize that the company's lawyer is not your lawyer.
This is a Security Weekly production. Security Weekly is a resource of Cyber Risk Alliance.
The Cybersecurity Collaborative is proud to present CISO Stories. Each week, CISO Stories takes a deep dive on security leadership with one of the contributors to my latest book, the best-selling CISO Compass: Navigating Cybersecurity Leadership Challenges with Insights from Pioneers, as well as other top CISOs and industry security leaders. The Cybersecurity Collaborative is a unique membership community enabling cybersecurity leaders to work together in a trusted environment. To learn more, visit securityweekly.com/CSC or visit cyberleadersunite.com. I'm your host, Todd Fitzgerald, and this week we welcome Larry Dietz, General Counsel at TAL Global Corporation.
Well, Todd, as you know, I retired as a colonel from the Army Reserve, but way back in the 60s, I was in a part of the Army called the Army Security Agency. And my jobs were essentially cybersecurity related in the sense of I gave a briefing to senior officers whose FM radio transmissions were intercepted by the Viet Cong. And the Viet Cong was in their little spider hole diligently copying away FM radio, tactical radio, which was not encrypted at the time. And you can't tell a senior officer not to do stuff. They really don't like that. And so I had one briefing where I had a guy's name up on a 35 millimeter slide. He was sitting in the front row. And then I did crypto facility inspections. We might call them threat assessments today. And that was circa 1969. And I've been involved with the cybersecurity field. On the military side, I was a market research analyst for the market for cybersecurity stuff for a long time. And of course, did a stint at Symantec. And so I've been doing it for a really long time.
Well, that's pretty amazing that the messages then were unencrypted, because we've had encryption technology for a long time.
Well, that's right, Todd. Don't let me misunderstand you, and that is that some of it was indeed encrypted. We had teletypes that were encrypted, and there was voice encryption gear for radios, for Jeeps and other vehicles and land-based, and there was encryption gear for helicopters, but not every tactical radio was encrypted. And before the National Cryptologic Museum was redone during COVID, they had a little tiny section on this top secret stuff from the late 60s. Whether they have it out now, I don't know. But if your listeners are interested in cryptography at all, and they get right near the Baltimore, Washington airport, Fort Meade, on the outskirts of Fort Meade, in what used to be a Holiday Inn, is the National Cryptologic Museum, and it's a great take for crippies.
Oh, I didn't know that. So today we're going to talk about the relationship with a CISO and their lawyer, and those things that the CISO should be aware of, when approaching the law. And we've had, several cases lately. How does a CISO protect themselves in this environment today?
Well, first of all, the CISO has to recognize that general counsel is the company's lawyer. General counsel is not the CISO's lawyer. That would be step number one. Step number two is, if you've made it all the way up the ladder to CISO, you're a reasonably technical person, And you can read this gobbledygook we call the law. And there are very different environments. There are environments where the CISO and general counsel will be natural allies. So, for example, if the CISO is going to buy a new cybersecurity product or service, then general counsel is an ally to go through the contracts and the NDAs and all the other paperwork to make sure that the company is getting a fair deal and that the company is as protected it should be. In the area of privacy, the CISO and the general counsel are foxhole buddies. One of them provides kind of guidance on the law. And as you well know, Todd, data privacy laws vary sometimes from state to state, certainly from country to country, GDPR notwithstanding. But there's a symbiotic partnership here where counsel says, this is what the law says, and the CISO says, this is what we're doing. And so that's pretty good. When can the CISO and the general counsel not be foxhole buddies? That's where something bad has happened, and there could be blame and or legal liability.
So I know in organizations, a lot of lawyers that I've worked with, there's one word, it's the B word that they tend not to like be mouthed, and that's the breach word. So how do you differentiate between, breaches and incidents and events, and, from a lawyer's point of view, what rises to that level where you say this?
Well, first of all, most of the laws related to breach and breach notification are pretty clear in terms of what the criterion is. And so, once upon a time, Symantec acquired a company called RipTech, and RipTech was a pioneer in managed security services. And what they taught me was that there is an evolution of things. So we have lots of events that happen, and then we have some events that are really serious. Those are called incidents. And then we have incidents that are very consequential. We call those breaches. And so what the CISO needs to do, the CISO needs to understand the extent of the damage and the potential damage, and they have to be comfortable that they understand how that relates to the law and the notification law. They also should be smart enough to know that the company wants to be able to blame somebody lots of times. And it wasn't our fault. We hired this guy. He was a CISSP and a BFD, and he had an incredible number of initials. And he always went to RSA on our dime to get smart. So we relied on him, and he screwed up.
So when is that case then that person screwed up, or the CISO screwed up, versus the company didn't make the right investments or have the right policies in place?
Well, first of all, you have to tell the truth. You cannot call an elephant a giraffe. If you had an incident and you paid blackmail money to get your ransomware decrypted, you cannot call that paying a white hat hacker some kind of reward. You have to tell the truth. And that's a key part of it. You also need to know the consequences. Mostly they're liability issues, and it wouldn't hurt for the CISO to have a cup of coffee with general counsel and say, can you explain to me kind of the basic elements of negligence? What are those basic elements? And those elements in the sense of common law are the gravity of the harm, how big is it, the likelihood to occur, how likely is it to occur, what is the cost to prevent it, given the big sphere of things, what do other organizations who are similarly situated, do, and what is the due care? What is the due care that you are supposed to do in that environment? So, for example, if the company does not have multi-factor authentication, which is kind of a standard today, and they deal with PII, and they don't have multi-factor authentication, that's not good. If they're in the toilet paper distribution business, and all they deal with is toilet paper, and their money systems are separate from their inventory systems, and they're never linked, and they have a lower level of security than the bank, that's perfectly okay because they're doing what every other toilet paper distributor is doing.
So how do I make that assessment to say, okay, I should be having MFA, or, you know, I'm okay with a complex password. Where am I going? Because all these standards have.
Well, the first thing, if it were me, the first thing I would do is I would talk to my peers in similar companies in the same industry, assuming there's no antitrust, NDA stuff. So you need to know what your comparable company, what other people, the reasonable company in the same industry is doing. That's the baseline.
Is that what would be presented then in court?
Yes. Yes.
To show what your competitors are doing?
Yeah. So if you are the linchpin of the internet, a SolarWinds, you should be held to a higher standard than the guy who distributes hot dogs.
Mm-hmm. Absolutely. And we did a CISO Stories podcast not too long ago. Tim Brown, who was the CISO of SolarWinds, was very transparent about what happened, how they reacted to the breach, and then the steps that they took after the breach to help the rest of us, because we all can be in that situation where we end up with a breach.
The other thing you can do is, as a CISO, you can do your own threat assessment by level of actor. You know, what does your organization have that might be of use to a nation state? We have a number of nation states that have very robust cyber efforts. Some are more well known for cyber espionage than others, but everyone could be a target for one reason or another. If not you would be a gateway. For example, the Target breach. As I recall, Todd, the Target breach was through a third-party HVAC contractor. So if you were Joe Air Conditioner, you would not necessarily feel you are a target. But if you are the target CISO, you have to ensure that everyone who accesses your network has the same level of security as you have yourself, because if they don't, they're a weak link and they're going to be a way in. So as part of your job as the CISO working with general counsel, you have to make sure that there are contractual terms that bind your vendors, suppliers, to the same level of security that you maintain at least. And give you the right to inspect that in one way, shape, or form.
The article this podcast is based upon can be viewed in the best-selling cybersecurity leadership book, CISO Compass, Navigating Cybersecurity Leadership Challenges with Insights from Pioneers. How much success do companies have in changing those contracts? If you're working with, say, one of the large software vendors, and they give you this language that they have pretty much no liability for their software if something goes wrong. How much? Well,
there's several different aspects to it. The software liability is one thing. You know, the vendor is obligated to provide you with a product that is fit for the purpose for which it was sold under the Uniform Commercial Code. Okay. What is often in contention is indemnity. So if I buy XYZ cybersecurity suite and I'm hit, is vendor ever liable to me for my attorney fees and whatever other money I'm out? Indemnity is a key aspect of a contract that's always fought over. Another thing that's that's perhaps overlooked but worth looking at is jurisdiction. There are some jurisdictions that are favorable to companies and others that are favorable to employees. And so you have to understand the nature of the law of the jurisdiction that the contract has. Many vendors will want to have the law governed by the law of their home state, whereas many customers would be better off having the law governed by the state of the customer. And how difficult is that to change? I think it really depends on the vendor and how important a customer you are. Most vendors of any size have the ability to contract local attorneys in other states and are trying to do business in virtually every state. So it may be a non-issue, but it's up to general counsel to go through that, not necessarily the CISO's job.
So for these indemnity clauses, what I've seen is up to the cost of the software, for example. Do you see?
Well, there's the limit and the trigger. So the triggers can be just plain negligence, gross negligence, and criminal negligence. And those are successively higher bars. So the indemnity doesn't kick in until the bar is exceeded. And if I'm the vendor, I want to limit you to the amount of money I spent. I don't give you any more. Mm-hmm. And then it becomes a business decision if the client company, the CISO's organization, wants to take that contract or move on to the next vendor.
So what would it take to rise to the level of, say, gross negligence?
Well, gross negligence would be, in the cyber sense, kind of what we talked about, where you have PII and the standard of the industry is MFA, and you're not doing it. You know that everybody else is doing it. You're the only one not doing it.
Absolutely.
Another thing might be having lackadaisical offboarding procedures. In other words, when employee leaves or is fired, an employee turns in their laptop, but their accesses need to be shut off immediately. And I've seen situations where that hasn't happened. The guy, here's my computer, but I have another computer. Mm-hmm. Those are gross negligence. And criminal negligence is where you commit a crime. Mm-hmm. Take a bribe. I might take a bribe as a criminal act. And because I took a bribe, I'm in a stretch here because I'm clearly not giving legal advice. We're educating here. If I take a bribe and we buy an inferior piece of equipment or an inferior service and we get hit, and it's proven that's because the product was a piece of crap, is that criminal negligence? I don't know. Could be. Mm-hmm.
Yeah, the whole other computer, I think the teenagers have caught on to that today with taking away their iPhones. They keep the old version of the iPhone and they kind of.
Well, I think the most elegant story I heard about that was one of my colleagues on a military gig has two daughters that are 2 years apart, and they're pretty smart. They take up to their mother, not their father, and she took her iPod and was able to make phone calls from it. So she converted her iPod into mostly an iPhone, which I couldn't. I don't know how to do that, but yeah. I don't have to.
Yeah, kids are the greatest hackers in the world because they go to their social network called school to figure
right, and they have no fear, and they don't have conventions. They're not boxed in.
So we talked about this. We touched on this just a little bit. That Joe Sullivan case, that we've had. Has shown us that all the CISOs are on the front lines when it comes to a breach and the legal aftermath. Should CISOs be concerned, or what should CISOs be doing today in this environment?
Well, they should be very concerned anytime there is a significant breach, and significant really is a function of the facts. They should understand that Mr. Sullivan's big charge was misprison of a felony, which is according to, I know you know this, Todd, but 18 U.S.C. Section 1505 says, it is a crime to corruptly influence, obstruct, or impede, quote, the due and proper administration of the law, end of quote. So they're obscuring the truth. They're making it difficult for law enforcement. They're lying about what they're doing. These are all things not to do. As it turns out, the failure to report a federal felony is not a crime. The defendant has to have some kind of act designed to conceal the fact that a federal felony has been committed. And recognize that the company's lawyer is not your lawyer, and recognize that you need a lawyer that's very familiar with the situation at hand. Just because your cousin Vinny is a great car accident attorney, it does not mean he understands the nature of any legal action that might come out of a breach, a data breach.
Mm-hmm. So in terms of the CISO role, is there, what sort of protection should the CISO be putting in place for themselves? So, because I think in this case with the Joe Sullivan case, it's clearly that the rest of the management were not wrapped up in that. It was the CISO that was targeted, with the fines, and the person who is charged to protect the organization's assets. And so, whichever side our listeners may fall on in this particular case, as a CISO listening to this podcast and wondering is there something I should be doing to protect myself from ending up in a situation where, management may be saying, well, this was the CISO, this was all the CISO's actions, and, this doesn't involve us. What should I be doing?
Well, never having been a CISO, I can only speculate. So the first thing I would do as a condition of employment is I would have my employer get me professional liability insurance that would protect me in the event of some kind of breach or malpractice like activity. So professional liability insurance would be something that I would insist on. Depending on how high up in the organization, there may be a blanket policy for officers. And if you're a C officer, in theory, you're part of the C-suite and you're a top executive, so you would be eligible for that. The other thing is I would have a personal knowledge of the laws that relate to cybersecurity. Breach notification laws, data privacy laws, and I would be especially aware of those that have criminal penalties. I would be especially sensitive to that. Wouldn't expect anybody to really be in the nitty-gritty, but as you know, Todd, there's only 83 billion cybersecurity publications around that cover that.
Well, this has been fascinating, Larry. Is there any additional advice that you would give CISOs, whether they're emerging CISOs, new CISOs, current experienced CISOs, as they're navigating the legal waters, whether it's personally or for their organizations?
Well, one thing is if you were doing the right thing, documentation is very helpful. Routine documentation of what you're doing is very helpful. Routine documentation showing your due diligence is admissible in a court of law. Documentation specifically written to deal with the litigation may not be. It may be a business exception rule. So document things that you're doing that are due diligence. Be sensitive of those areas that have criminal liability, and understand what kind of target your firm may be, to understand the nature of the threat actor that might try and go after you. And of course, keep aware of what's happening in the industry. And if you can, develop a cooperative relationship with peers who are similarly situated. And perhaps another thing is, think about that one phone number you have in your wallet if it looks like the company is going to try and put you in the hot seat for the breach. So you don't have to scramble around Googling white-collar defense attorney in Poughkeepsie.
Mm-hmm. I think does Poughkeepsie have a lot of those defense attorneys?
I imagine they should, because they were and maybe are a big IBM town.
Okay, very good. So, well, thanks, Larry. It's always a pleasure talking to you, and thank you so much for joining us today.
It's been my pleasure, Todd. You take care.
Thank you. Visit more CISO Stories podcasts on securityweekly.com, where you will find an index to prior episodes. The Cybersecurity Collaborative is a unique membership community enabling cybersecurity leaders to work together in a trusted environment. To learn more, visit securityweekly.com/CSC or visit cyberleadersunite.com.